Now that we've got the basics of the principal-agent relationship, we can start talking about partnerships and then the more complex form, which is corporations. So now we're on partnerships, which is an association of two or more people who enter into business together for purpose of making a profit. If it's only one person, then that's a sole proprietorship. If it's two or more, then it's a partnership. Partnerships don't have to be in writing. There don't have to be any formalities or legal niceties, as long as they're working together to create a profit. They are a partnership. And certainly if both parties are sharing the profits, that's going to be deemed prima facie evidence that a partnership was created, and so forth. And so courts will consider not only the sharing of profits, but also whether they have joint responsibilities, whether they share ownership, whether they share management rights, things like that, in determining whether a partnership has been created. And because it can be created without any formal agreement, a partnership is really the default form of business. So if a couple people start working together, it's a partnership until they create some other legal mechanism like a corporation. Now, a partnership by estoppel arises when a person indicates to a third party that she is a partner when in fact she's not a partner. And in such cases, the person will be estopped from denying her status as a partner. So she can't say or give out to someone else, oh, you know, I'm basically a partner in this enterprise, and then later say, well, no, I never agreed to be a partner in this enterprise, because she will be estopped by the fact that she led a third party to believe that there was a partnership. Now, any property that's brought to the partnership or subsequently acquired for the account of the partnership is considered to be partnership property. And so any property that's acquired during the time of the partnership using partnership funds, that's also going to be partnership property, and potentially then stays with the partnership until it's dissolved. Turning to relations between the partners, unless there's some other agreement, all partners should share equally in the profits and losses of the business, and all partners have equal rights to manage the affairs of the partnership, which is true even if they don't share equally in the profits. If you want to do something different, you can, but you have to write it out in a partnership agreement. And partners, like agents and principals, owe the highest financial duty of care and loyalty. So they must carry out their duties using reasonable care. They must act to the benefit of the partnership. A partner cannot use property or assets to benefit of the partnership to benefit herself. All acts on behalf of the partnership has to benefit the partnership as a whole. They can't just enrich one of the partners at the expense of the others. That would be a breach of the duty of loyalty. And importantly, a partnership for tax purposes is subject to what's known as flow-through tax treatment, which means that the partnership doesn't get taxed, but to the extent that each partner gets profits, those profits get taxed. So the profits flow through the partnership to the individual, and then the individual may get taxed, but the partnership doesn't, and the partnership retains more of its funds. With regard to liability, a partnership is simply a larger agency relationship. So each partner's actions are potentially binding on the partnership as a whole, because each partner is acting as an agent of the partnership. And so they're acting either with actual authority or apparent authority to somebody in the outside world. And so that partner's actions will place the whole partnership on the hook, potentially, for liability. And importantly, each partner is personally liable for the debts and obligations of the partnership. This is very different from corporations, which, as you'll see, have limited liability. So here, in a general partnership, everyone in the partnership is liable for the debts and obligations of the partnership. Now, a partner's liability can change if the partner is considered a limited partner, and that means that the partner is really only a partner for certain limited purposes. Usually that means that the partner has given money to the partnership and wants to be involved in the profit sharing, but is not involved in the day-to-day management. So if you're a limited partner, then you wouldn't be subject to liability. But general partners all are, as I said, jointly and severally liable. They're individually liable. Now, if you admit a new partner to your partnership, that partner is only going to be personally liable for debts and obligations that arise after the person becomes a member of the partnership. Similarly, someone who retires is only liable for the liabilities that occur before the retirement. And finally, if we want to look at the dissolution and termination of a partnership under the Uniform Partnership Act, which we've looked at uniform laws before. They get enacted state by state by state, but they tend to be the same from state to state. A dissolution represents a change in the relationship of the partners caused by any partner ceasing to be associated with the partnership. Notice, any partner. So a dissolution can arise either by a specified period of time elapsing. So if the partnership agreement is only for 2 years, then at the end of 2 years, dissolution. Or the express desire by any partner to end the partnership, or if all the partners decide to end the partnership, or if any partner is expelled, or if any partner dies, or the bankruptcy of any partner or the partnership, or by court decree. All of those things could be dissolutions. So again, unlike corporations, as we'll see, partnerships can dissolve fairly readily if only one partner essentially decides to move on. Now, those partnerships can reform each time. Famously, let's say a law partnership, if one partner leaves, the other partners can immediately decide to reform, but it needs to be done through an operation of an ongoing agreement. Now, dissolution terminates the authority of all partners to act on behalf of the partnership, except to perform whatever acts are necessary to wind up the affairs of the partnership, pay off whatever debts might be owed to creditors, pay off any partners who've made loans to the partnership, and so forth. And if there's any money left over, then that would get distributed equally or by whatever terms the partnership may have. So that's what partnerships are. Now what we have to do is distinguish between partnerships and other kinds of forms of ownership and operation of joint ventures. I mentioned that you can have a partnership that have limited partners and general partners. You could also have a limited liability partnership, or an LLP, which has all the features of a general partnership, except that you need to file something. You can't just sort of make an agreement and start doing it. You have to file something with the relevant governmental authority saying that you're going to be an LLP. And in an LLP, personal liability only extends to partners who commit a wrongful act or who are responsible through vicarious liability for supervising people who commit a wrongful act. So everyone else would have limited liability, and so that makes it a little bit different from the general partnership. You could also create a limited liability company, not a limited liability partnership. A limited liability company is an entity in which the people who've made the financial investment in the company, known as members, don't have personal liability. And there can be a variety of management structures. So all the members of the LLC could participate in the management of it. So that would make it like a general partnership. And then it's a member-managed LLC. On the other hand, the members might be separate, and the managers might simply be authorized to manage the affairs of the LLC. That's called a manager-managed LLC, kind of an odd name, but it's to distinguish it from one in which all the members, all the investors manage the LLC collectively. And then there are corporations, and that's what we need to look at next.